Okay, everyone, welcome to the Brilliance in Commerce House of Freedom International Natural Law Trust Zoominar with my name is Tonson, and we're going to have Randall Hillner, our writer and trust creator extraordinaire, join us. Brilliance in Commerce is a project of la vérité, which means the truth in French. So we have a lot of financial freedom tools, as you can see, for privacy, freedom from debts, freedom from impositions from third parties who have no business taking what isn't offered. And so consistently, you can see the principles being adhered to of the Worldwide Charter for International Commerce, of which we are an honorable signatory. Today is September 18th, 2024. Welcome everyone again. Welcome newcomers, new subscribers, new clients, new customers, and our old friends who've been with us for years and years. November 13th is the next trust webinar and the last of the year. So this one, again, as always, will be posted on YouTube. And house-of-freedom-trust.com is the link that leads to the trust site. But if you have an affiliate who is working with you, you would best use that affiliate's link. For those who need it, our phone number is 360-200-7521 in the United States. My name is Tonson Fairmont. I'm very grateful for all of you to be here. We are watching an old world collapse and come to an end, and we're paving the way for a new golden age to be dawning. So Randall Hillner is our trust department head. Those who have seen his webinars before are familiar with him. My old friend, and since the early 1990s, and still going strong at an advanced surfer and yogi age in the beautiful island of Kauai, Hawaii. Founder of the House of Freedom Trusts, White Light Unlimited, One People's Public Trust, and the creator of International Natural Law Trusts. Working with him on occasions and when needed is Laurel White. She's been providing a lot of nominee grantor services, and she has various other fields of expertise, non-statutory private membership associations, and various skills and talents that have been harmonizing with us. Today's topic is a continuation of 2 months ago when Randall began the equity and trusts theme. And so now we have that theme continuing in part 2. So Randall, if you will please unmute and turn on the video, and I ask you to proceed.
And I be heard?
There he is. And what happened to the ocean? You're not by the ocean this time.
I just switch it up.
Uh-huh.
Try something new. Although I didn't preview it, so I didn't realize that this is rugged. This must be up in your country somewhere.
Uh-huh.
Okay, let's get on with the show.
Okay, so first slide, the roots of the trust.
This is so dynamic how this all works. The basis of a trust and the basis of how humankind interact together is so complicated and simple and tight and unbounded, and it's just amazing. And I see stuff like this that you got posted, I go, wow, this is how we should see it, be able to see it, tune on a certain channel and dial it up and tune it in, but on a positive note that runs strong and builds really solid light bridges, etc. So all along, I think I've been talking a lot about how the trust started in Greece and the Baghdad. And now I know I've done more research, and we're finding that more and more there's kickback not only to trust and equity and commerce in the world trade, but that extends to all avenues of whatever that commerce might be. So it doesn't have to be necessarily a trust or an equity or a partnership or a marriage or whatever. It should just be a contract where one or two people or more are called together and they create a trust that holds their promise of the vision together for the benefit of their beneficiaries. It's either sometimes it's the beneficiaries of the grantor, sometimes it's the beneficiaries can be the beneficiaries of the trustee. Usually the beneficiary gets to just receive it and he says, "Thank you very much. I'm out of here to the beach." So that's how it works. And what happens is, but in the early days, in early common law, it was held high and held high esteem because at that point there was a lot more. Let's see, before the age of collapse, around 1200, 1300. And what we found in the research is that all the way back to even 500 BC, or Common Era, whatever you call it, is that people of high rank in Eastern Mediterranean and that whole area there, and then even into northern Africa, and into findings in Baghdad that are, 5, 6, 7,000 years old. So it's truly, I'm really astounded by it. I've been hanging in around this whole demonstration of how to put together a proper trust document, and I
Did
just
the
keep
pharaohs put their pyramids into a trust?
why not? You have two trustees that can carry the load and be successfully fiduciary responsible. Sure, we could do that. Takes more than one person, of course. That's where your separation comes in. What happens is on a revocable trust, people begin to think that because of that, they have the terms to revoke it. And they don't know what the term truly means, and they have never heard the term irrevocable, so they probably don't want to hear it because that's what the lawyer told them. But once they get the wrath of that ability to separate themselves from the asset or the cargo of the trust, then there's a tremendous amount of respect and esteem for those people that carry it forward. And that's how it's become a really not a one or two man show, but 3 and 4 people. Because in Europe now, in Britain especially, and in France, they're changing, and even the laws of the Arabic laws are still entrenched in that ability to take the concepts of what our culture believes in and put it trade or commerce, equitable commerce trade on the planet and make people more happy than they've been in the past, and we might have a good place to hang out. Is that okay for a start, or do we need more?
That's good.
The Baghdad, yes. So again, and I've been, Dominique will back me up in this, but I've been working with Dominique the last couple of months. And I used to love geometry, and I built houses for a while. And so I knew that whole concept, and that's how equity law is based. It's based on a balance, how you have to have honesty with all 3 people or 4 people involved. And you have to sign the document that says, I hereby put my fiduciary responsible on the line to make this trust what it can be. So that's what the whole East Coast, I mean, it's the ramifications of where all of these trust laws came from. It's pretty dynamic, and I'm really happy that I can share the load, and other people are coming on. I appreciate that. I appreciate that I got people like you coming in and listening to me. And I know some of you have heard this for a while, but Every once in a while, you get that spark and another layer unpeels. And that's why I liked it, because it began to take me not into the financial world, but that mathematical world. And then the Sufism, the mystical world. So there's the mind, the body, and the spirit all in a place. Every one of those concepts can be held in entities using concepts of all those three things. Does that help? Help. Page, please. So here we go. Here's where that split of ownership begins to come into play. So we're going to divide it, let's say, usually the initial response or initial example I use. It's like here you have a family of 4, and they're sitting down to make sure that they're going into, it looks like one of them's adulthood, going into young adulthood. So they want something that can take them into that process really safely, and within the construct of all of that, with the reduction of what the possibility of tax ramifications are, if they don't do it sooner than later, is significant. And so a lot more people are coming into the common law and into the statutory law and trying to do it that way, and have entities on the other end that are kind of dubious or can be dubious, but can be addressed and can be run successfully if you do that. I like to say, okay, I want it, the premise of what I want to do with BIC and what we've been doing, let's take that up and really step up brilliance and commerce into the field of equity, where all the things that we present on the table and all the way that we treat the clients that we have, we treat them in an equitable manner. So everybody you have to pay the dues, you have to have money to get in, money to train, but ultimately on the end, it comes down to you having all of these funds available for your children, or into your family adulthood, your family's adulthood, into the elderly estate, and you know that your estate is going to be taken care of. There's multiple generations down the road, as you like it to have. That's the way I look at what we do at BIC, and I'm really happy that we're here, and I'm really happy that Tanzan has given me, again, a nice choice to come along and share my responsible fiduciary capacity. Okay.
We had a request from at least one person, if you can turn up your volume. I don't know if you can get closer to your microphone.
How's that? Everybody, can you hear me now? Can't even hear me.
Yes, but well, Sue, I think you were asking.
Anybody else? Do we need to wait a few minutes?
And turn it up on your end as well. You ready to go next?
I am. Well, next slide. Yeah.
Okay.
Yeah. Just as I talked before, this is the whole thing. This is what carries a really good trust document into a realm of all possibilities without having to be tagged with the two major complaints are in the commerce world, the commerce statutory world. Two of the biggest complaints are is that they get bound up in this premise that they're doing the wrong thing, and they need to give it all over and use these statutory prerogatives to help you understand how to make it work. Where in fact, if they were teaching you how to do common law and equity law and stepping into the law of contracts with fiduciary responsibilities, equitability all through the trust, whatever you're using, whether it's in the business itself or through the trustee selection process, then that's where you want to go. I think that that's what we do. We set the whole trust concept up, train you how to use it, how to step forward, how to gain power, how to take care of trustees if there's a problem, how to become a trustee if you want to do that. It's hard to start your own entourage of setting up the clients that you have in whatever business or home process you may have, and have the ability to take your clients in your business and replicate the same thing with them. So if that's something that you want to look at, then that's what we're here to do. And that's what we love to do, is present all the options that you'll have. So now we'll get into what are the fiduciary responsibilities of a trustee. Here comes the sun.
Fiduciary obligations.
Yes, please. Distinguishing people in legal. I looked at it, I said disgruntled people and horrible owners, but it's distinguishing people in legal capacities. There's a lot of stuff going around in the counterculture or the woke culture about how to sign names anymore. I don't even want to take that on. I don't understand it, but there are ways to keep yourself. And ultimately, for me, it comes down to two ways. You do it through one side in the public on the statutory side, and one action on the private side, where it's in your own private side of dealing with the whole element of living in the conscious fiction world. So trusts are both. They can mix fiction and in fact. And we remember all that, just the man's fact. Well, that's what we can do. Now, what we can begin to get into is that in the corporations, if the corporations have a sense, the reason they were created was to help owners step in and take some of their profit and get a reduction in their tax status if they would give back so much paper currency or whatever their net worth was when Rockefellers had their, still have their abundant regime. But it doesn't matter. The fact is that those structures came into being, and now everybody has that ability to run those. And we can run it more on the private side than dealing with the public side. But it only takes a minimal level of learning how to switch between the private side and the public side, that you can't afford not to do it. So it's a great scenario to be in. So is there anybody else got a tag on that? They need more information?
Yeah. Any questions relating to what Randall's talking about, you can put into the chat.
Anybody? No, everybody's gone. All my associates all left. They thought the thing was over, I guess. I'm sorry. Okay, and you live public and private. Oh, do you want to stick around, Townsend? Do you have time?
Well, yeah, but we haven't opened it to Q&A yet.
Well, okay, all right. Whoever joined me, let's start. If you can wait a little bit. Okay, next question. Okay. I know where that place is. So what do we have with Dixon Trust and other legal entities? So one of the things is, first we say we have a contract. What's a contract? It's a decision between one or two parties that are going to take a particular asset and put it into a trust. He's going to say, I have a friend and I have a piece of property and I have children, and my mission is to go off and fight the crusade. And I need to leave this property and few of my tenants with this person. And we're going to go off, and I would like to make sure that it's in good shape when I come back. Well, that worked really well because sometimes it was 2 years, sometimes it was, but it got longer. And what was happening is because the corporate law was still in action, only common law, the only thing was that the judge can go and say, slap the person that created the injury on the hand, say, you got to get the property back. And the claimant, the defendant could say, I don't have it anymore. We were short on money and I had to eat them to get through the winter. So this is one of the things the contract and a bailment is who's claiming what's in the bucket, bucket, bailment. Agency, are you working in a third party capacity to be an agent for, could be a a trust, could be a bailment, a contract, could be a plain old contract. Contract out in the street, you have a friend, he says, hey man, I'm short, can you go in and buy me a Coke and you know, not a donut for breakfast? And he gives you $1. And you go in, it's only 50 cents. And you go back out and you give him the donut, but you keep the 50 cents. So ideally, you have acted as a third party, but you've created fraud there because you have not given full connection with what the agency was at. So that's something to watch out for is how you treat your client when you're going into it. And then gifts is it an outright gift? Is it upon a certain situation? Does it hold certain parameters to it? When I look out into the future, can we change it? How can we change it? Or how can we define it? How can we create the next generation of people who will come in and grasp the idea that we have, and yet still take a task to not only empower what exists in the realm of contracts, multiple contracts, layers of contracts, and put them into the ability to be reinterpreted to a lot of today's trust law. And that's what I want to explore, certainly in the next couple of months. And I think we'll do one more. I think I'll work my way in next month, the next session. Might do a seminar just on that. You know what I'd like to do. If you have any, you can do some research, do some look at Google research and find what on these 5 things here, what they can get on research. And we'll pick it apart and have fun with it in October. Be great, or November. Any more questions? Because I'm still cranking up here.
Well, we have lots of questions, but I think that's the last slide.
Well, want to go with questions?
Okay. So Dawn is saying that common law does not exist. There hasn't been a government since 1999, the third and final bankruptcy of the former United States corporation.
I don't know whether it was a former United States. Excuse me. I don't think the United States was a corporation until the 1900s. And I think that the true government, most of the states were running as republics.
And it's true that it's hard to get common law in any kind of court case, but first of all, that's why we haven't had court cases. We stay out of trouble, so we don't have to take the trust into court. And secondly, natural law is the essence of common law. And natural law has no beginning and no end in this universe. So as long as one doesn't harm another or violate another's rights, there hasn't been any trouble, hasn't been any problem, whether people agree that common law can be invoked or not. And it appears we've lost Randall temporarily. He's off the screen. I don't know what happened. In the meantime, Josanne has asked, will the proposed or designated grantor have to show up with the trustee at the notary public to get initialize the first or 10 or 12 sheets of the trust document? And Josanne, no, the answer is no, that is not required. The nominee grantor or the grantor can be anywhere in the world, and he or she can sign the document at home, and it can be contributed to the trust remotely if desired. And if you, the client, wish to be trustee, we recommend that you use a grantor in name only, nominee grantor, which we provide, as you may know, for $200. Or you could have a friend who can play that role, that perhaps they'll do it for free. Because all they do is sign on and sign off at the beginning of the trust. It would help if it's notarized, you know, and depending on what country you're in, notarization may or may not be easy. It's pretty easy in the United States, and it's free, but or usually free, depending on what bank you go to. It's the notarization laws say that it should be made available without charge. So that should answer that. Larsana, you ask, how can you live public and private? You live private by withdrawing your support from the public agencies that are harming the world, and by moving your commercial affairs into the natural law trust, which is private, and you don't post it on state record, you don't have an attorney created, and you keep your books private, your documents in your computer private, and the information about its existence private, except for obtaining the ID number. And so the system will know the name of the trust. It will know who the responsible party is. It will know that the trust is irrevocable. But other than that, there will be no information. There he is, Randall. Are you back? Okay. So let's ask you to unmute.
Right? Can you hear me now?
Yes. Glad you're back.
I'm back. Anyway, we'll chase that around some other time.
Okay.
I'll be looking forward to it.
Okay.
You have questions, I assume, or if I can help?
I was trying to help a little bit with the Q&A, and so Larson was asking about public and private, and I was just saying that you can keep your affairs private through the trust, but you can interact with the public through having a bank account or a securities institution account. So as a sovereign, you have the right to interface with the system and the public. So you can interact with the public while remaining private yourself. Anything more on that, Randall?
Yep, there's always more. This is a particularly intense conversation, so this is the important step, knowing how to step between two of the worlds, public and private. So right now, most people think about having like an LLC for a business and maybe a sole corp for some other side, and then a company for the main thing. And so they can run pretty freely, but then at some point they don't have a lot of liability, and they actually do have a liability if there's a fraudulent claim that the peers can, the veil of privacy can be pierced. And then even though it wasn't necessarily the fault of the CEO, because he was in charge, they can tag him for it.
Yes.
Let me finish, Will, and I'll be right with you. Nope, I just lost my thought. Go ahead. Okay. Will?
Next question is why?
Let me finish this, but the idea is that what we can do here at BIC is that you don't have to have a foreign corporation or an LLC in a state that you're not familiar with or something like that. You can have you can have two trusts if you choose, if you live in a state that doesn't really play fun with private trust, then we can train around that. But basically, the trusts have one for the private, it holds all the family equity that they want to run down for the legacy of generations. And then they have their temporary time on this particular planet. And that's the whole thing about the trust. It goes far beyond the corporate structure. Never to mind what Tanjan mentioned the last time about corporation can change their laws, their financial laws anytime they want. And then if you don't have it set up properly, or you haven't been informed of how they might do it, then you better watch out.
Well, you
So that's my take on that.
you brought up a good point in that you can have more than one trust, one that deals with your private life exclusively, and you can have another one that deals with your business, your investments, and it may have more interaction with the public, but its records are still kept private.
Yes, yes. And I think that has a PMA is private, and our trust is private. A non-sectary trust would be private unless you took it into the public domain yourself. But if you know about that, then that's minimal activity. So I think it's a good thing to have. What I'm suggesting, I have a law class going, and I have a bibliography, and if you want, I'll send you anybody that requests it sent to the BIC office, if that's right, and say you want to have the bibliography for Randall, I think it may even be posted there. And then if you have questions beyond that, I want you just ask what I feel is best for what you might need. I'd be happy to spend a little limited amount of time doing that for anybody that needs it. Because a lot of my clients lately have been having a hard time to find what role to play, how it best fits them. Because in the past, most everybody has pretty much known how to, but we have a new slew of people coming in that want to learn how to do trust and, and a really honest and transparent company. So that's what we're trying to do, is lift up the whole process.
Donna is asking, why is a corporation fiction?
Just the way the fiction ran, and I don't know if it's English. I don't know. I've never seen it English. But in the early days, I've seen most trust contracts, any of the corporations were really flowery, uppercase, lowercase. Fictions came in when the corporate governments got really stringent on what they were going to do and how they began to withdraw the power away from the people. And they began to put more and more cloudiness in the recipe of having having two trusts and not being able to, should be putting in at least one of their LLCs so they can tag you for a bunch of money. So the best thing is to get work. There's 3 or 4 states that give really good private LLC work or non-statutory corporate structures. And if you like that, if it's not on the BIC site, you can access me. I'll give it to you and go from there. If that's okay, Tanzan, is that right?
Uh-huh, sure.
Okay, yes.
David is asking, if I am the trustee and the beneficiary of the trust is another trust, does that have any bearing on having a non-relative involved as a co-trustee, or is it best to still have a non-relative involved?
Well, ideally, you want to have as much action as there is a separation. But as far as factual goes, one trustee can run the whole process, and the second trustee or the successor trustee can always come in and bring things up to speed. But especially today with electronic stuff, everybody's got duplicates or triplicates or tenfold in a matter of a flick of the switch. Goes from one country to another. So that's not an issue so much anymore. But it's good to have the ability to have clarity and have transparency and have things done sooner than later, because as time, what happens with especially trust law, especially I think it's going to be building with the case law of equity law, is that they're going to form certain parameters, and those parameters will smooth out transition from common law to canon law. I mean, not corporate law.
Okay.
Anything else?
Our good friend Will Barney's asking, I would love to hear Randall's thoughts on sovereignty versus the trustee.
Okay, so a trustee can just look over a minuscule thing, but he contracts through a network of people. Like he's got to go to find out who's an excavator, who's got men to dig the hole, who's got the pipe letting, etc. And he's got to get a permit if it breaks a certain paradigm of that contract. But with trust law, something has to hold all that together. Whereas with trust law, each one can be its own separate entity and can, form its own parameters within that process of what the whole shebang is all about. So you get a multiple layer of resistance and cooperation and resiliency and transparency, and it's pretty good. And then also I wanted to say, with something else was sliding in there. It's like, I'll get to it when I come back. But
Will, would you like to raise your hand and come on verbally, and we can go into that just a little more detail? Because your question could also get into, has the trustee redocumented his or her own proper status with the government?
right, right.
And that helps. I always say it helps because it helps you to understand the sovereign nature of the trust as well.
Well, you best know what the full ramifications of being a sovereign nation is all about. Remember that one I gave
Yes.
you the other day about the sovereign nation, what you need to be a sovereign? Hey, well, so you can hear us. Can we hear you?
Okay, I'm
All right.
unmuting you.
There we go. Can you hear me?
Yes.
Oh, okay, great, fantastic.
Okay.
So, a couple of things. First of all, I want to clarify my question a little further. What would you say the difference is between living as a sovereign versus living as a trustee? And what are the pros and cons of each of those?
Well, one is the trustee. I mean, the trustee gets to be his gets to stop being his trustee once he's done his job for the day, or he's made sure everything's complete, at least up to date. And the owner on the other end will have to look after that property while he goes home. So in order to defend a particular cache of gold, you need this, this, and this, and this. We all know that story. Difference is a trustee can have multiple people under him. And as long as he has the right setup for all those documents, there's no veil to be pierced. And so even though it could be pierced, because maybe there's always fraudulent somewhere, it could be minor, but he can at least get into a trust or two. But if there's no fraud involved, or when the fraud is discovered and it didn't come with a trustee, then it absolves him from that whole responsibility anyway.
I was thinking about this recently, and I had the thought occurred to me, and you know, you can tell me I'm in left field here, but the thought occurred to me, okay, if you're going to live life as a sovereign and you're going to buy a chunk of land and put your castle on it, now you got to defend that castle, right? From somebody that may want it. If they want to come take it, they just come after you. How different that is versus being the trustee, because as a trustee, you don't own it. You're not the target. You're just the trustee. And it seems like that would be a much easier situation to be in versus trying to defend yourself. Just a thought.
That's my call. That's the way I'd go. No, I had one, last night. Excuse me. I'm so wet here. Right. They're wondering about the same thing. I lost my thought. Can you say that one more time, Will?
Well, the thought that I was having is, okay, let's say you're living life as a sovereign. That means,
Yeah.
and you buy a piece of land and you own it, right? Everybody sees you're on the record, you're the owner. If they want something from you, they may want to come and take that
Look,
because they know you're the owner. But if you're just a trustee, they don't know who owns it. You're just a manager. You're just a trustee. You don't have a target on your back. Am I right about that?
yes, you are. And the rightness comes in the fact that as a trustee, you're not having to defend the whole empire. You can defend the particular aspect that you want to play. If that means staying in the background and pulling the strings on a non-fraudulent manner, then why not? Whereas a sovereign has to be on top of, he's got 5 cardinals and they all have 20 cardinals and he has to listen to them every day. So I think the sovereign has more responsibility overall than a trustee. That'd be my
Yeah.
take. And it depends on I mean, Jesus, again, Japanese architecture last night, and they were talking about how the carpenter, the main carpenter of that company, goes up and selects the trees specifically for the new owner, and he looks at what they're going to be in 20 years. And if they're not ready to cut yet, he tells the owner to wait for 10 years, and then the house will be perfect for him to cut down because he's had that insight. And I think that's what a trustee can do rather than an owner, because he's got too much to do. Does that help?
Yeah. I think it does. And I think it's one of the things that attracted me to the whole idea of a natural law trust is I can't think of a better way because I've looked at almost every entity out there, and I can't think of a better way that you could actually protect an asset while at the same time, at least somewhat removing the target off of your own back if somebody's throwing arrows. It just seemed like a simpler way to do it. So I like what you're talking about here, that it doesn't have to be complicated. It just has to be structured in a proper contract form. And that's really the basis of this.
Right. And that's one of the key words that I tell all clients. I said, if you haven't got a trust and you want to, in the IRS, you think the IRS is coming down on you, it's going to take you 2 years before you have that length on that trust or any document that might be testing the fraudulent conveyance. So one of the things you have to do as a trustee, you have to know about that. And you have to get to your clients or your settler early and make sure that he's got that in order. And yeah, the more I read about trusteeship, the more you can't get me out of it at all. Where to go? Where can you go where you don't have what you have with well-written trust documents and trustees, et cetera, and participants? And that goes into the work that Laurel is doing, where she's on the mainland now trying to do the same thing with communities and set up the communities based on that whole process of let's figure out how to draw the sovereignship into a community. And then my job as trustee will be less contingent upon one person, and we can get more done and be more happy. Yeah. Does it make sense?
Yeah.
Oh, yeah.
Ah, that was nice. More question?
Anything else, Will?
Yes, just one other thing. And because this, I get asked this a lot where people are concerned that, okay, let's say I have the asset, I have the house, and I want to put it into a trust to protect it. Where do I find a trustee I trust? Right? How do I know they're going to take care of this properly for me and for my posterity? Could you touch on the ability to begin a trust and to put yourself in the trusteeship versus the grantor? That, because I believe there's ability to do this if people can understand how to do it.
We do that. That's our whole new document has come out on that premise that you can have a nominee grantor and have you can be the trustee with a non-related co-trustee or a related successor trustee. And as long as you're not the beneficiary, then that works. The only thing being is if you are the trustee and everybody in that trust is related, I wouldn't do it that way. You have to have that separation. But it can be done. It's what's been done for years. That's what I've been told and taught. Does that help? Well,
Yeah, I think it does, because the important part, I have a co-trustee that is not related to me, and
Uh-huh.
that was by design, because we wanted there to be not the appearance, right,
right.
of trying to do this, to do this family thing only, and nobody else is allowed in. And so I think that that's an important concept that should be there, because someone could target you if you're not following those principles. And I think that's an important part of that. The other thing that's interesting to me is grantors can put things into a trust, but there's really no reason a trustee couldn't also put things into a trust. Am I wrong about that?
Randall? I think he's got a disconnect on his internet again.
Oh dear.
But no, you're correct. You're not wrong. Right. I'll try to pick up until he can come back on. Um, yeah, he's lost internet.
Yeah.
Yeah.
So it just, maybe you can help me understand this, Tonson, but typically you have a grantor with an asset who's going to contract with a trustee to take care of a beneficiary. Okay, this third party,
Right.
which makes complete sense to me. But could you have a situation where you use a nominee grantor and the trustee brings assets in lieu of or in addition to?
Exactly. Exactly. That's what we've all done. All of us who are trustees of our trust, we put assets in, we take assets out. That's what is meant by discretion. The trustee has discretion. These are discretionary trusts. So, and you don't have to receive units of beneficial interest. You can just put assets in as the trustee, because that's showing good management. The goal, obviously, is to expand as much as possible the net worth of the trust for the benefit of the beneficiaries. So, yeah, if the trustee can add assets and multiply them, all the better. Correct.
Well, that would solve the problem for folks then. If they're, I'm going to use the house as example. So put the house in a trust. How do you get the house into the trust? Maybe you've got it in an LLC, a corporation, or whatever. What would be the process of putting that into the trust if you're going to retain that trusteeship and continue to manage it so that you know it's taking care of yourself? What would be the process of making that happen?
You create a minute. The minute is a piece of paper, a document that says there was a meeting of the Board of Trustees and it was decided to accept the title of ownership of this property into the trust on this date and have everyone sign it. It's added to one of the schedules, C or one of the schedules in the trust. And then if the property is listed on public record, you would want to change the public record to reflect the new owner.
Oh, well, that's pretty simple then.
Mhm.
So you could create the trust first and then move the asset in afterwards, basically.
You have to create the trust first.
Yeah. Yeah.
Yeah. Good questions. Thank you. That's very helpful for everyone else listening, to have these questions come up and allow us to focus our attention on them and answer them. Yeah. You're welcome to just stay on there until Randall gets back. If you
Yeah. Okay. We'll see if he comes back on. there are probably some other folks here they've got questions, so I'll let them, we'll go to theirs. Thank you.
Well, you too. Yeah, thank you. So Deb is asking, how do you name and create a child trust? And is the parent trust then liable for the child trust? So, well, obviously, an adult has to be the trustee. And so, if the child trust is while the child is underage and their assets are being put into it on behalf of that child, then it would have to wait until either what age of majority is what 21 to take over as trustee. So in the meantime, the trustee would have to be the mother or the father or someone who is of adult age. And well, yes, then that trustee would be liable because that trustee has control and has responsibility for managing that trust on behalf of the child. The other way to do it, of course, is to make the child a beneficiary. But if you want the child to be the trustee someday, you could just do so. Maybe make the child successor trustee.
That brings up another question. I'm going to keep asking you questions, but the question is this. If a child is a beneficiary, but you feel that at some point in life that they are responsible enough to perhaps take over that responsibility as trustee, could they surrender their beneficial interest and then become the trustee? Could there be an exchange there?
Absolutely.
To change positions anyway?
Absolutely. And that brings up a good point that changes can be made to these trusts. They're not, uh, set in stone forever. Yeah. Trust officers can be appointed, can resign, beneficiaries can be added or subtracted. So, yes, it's a good point. Yes. Blair's asking, or no, Eddie's asking, my corporation was given a real estate property quit claim deed. Can I put that into a private natural law non-revocable express legacy trust? We got a full set of adjectives there. You want to comment on that, Will?
Yes, it's actually very simple. And of course, I have one of these trusts and I've put assets in, and I've done it just as Taunton explained. I wanted him to give you the explanation because I think it's important. As the trustee, you can call a meeting and you create a document, and you can even get this notarized as you desire, right? If you want to make this official, but where you accept the asset into the trust. Now, if you've got a corporation and you're the principal of the corporation, then as the principal, you have a right to quit claim that property to anyone else, even the trust. So you could do a quit claim to the trust, and then as the trustee, you could accept that quit claim through the document we talked about, which is the acceptance of the asset into the trust.
Short, sweet,
I hope that helps.
Yeah, short, sweet, simple, and succinct. Thank you. I hope that answers your question, Eddie. And then Blair's asking if our family has a recreational property that we would like to keep for generations, how would we be, how would setting up a natural law trust go about? How would we go about doing that with the trust? Once set up, does it become tax exempt? Does it transfer to the trust seamlessly? Why don't you go ahead, Will, and I'll add to anything you may have to say.
First of all, if you're doing this properly, these trusts are not an exemption to the tax law. They are an exception to the tax law. So you really need to differentiate that because it's very important. If you're setting it up properly, it is not a taxable entity. Why? Because you didn't go to a state to get permission to exist. You didn't go to the federal government to get permission to exist. So therefore, you're not in their system. Everyone that goes to them for permission to exist is a taxable entity because they are now your partner. And as a partner, they get to say whether you're taxable or not. if you look at, and I've done some research on this, but in the 5th edition of Black's Law Dictionary, we're probably on the 9th by now. I looked up the definition of the word owner, and what it said was an owner has the right to decide whether a property is taxed or not taxed. So only the owner can make that determination. Well, how does the government or the state determine you're a taxable entity? They're a party in your document because you're going to them asking for permission to exist. Therefore, you're coming to them as incompetent, and they're saying for a fee, we'll let you exist, but you're going to be a taxable entity. So that's really what is taking place there. With a natural law trust, you're not asking their permission to exist. You're creating a contract that is private between a grantor and a trustee to take care of the beneficiary. So it's not even in the system. It's outside the system altogether because it is private. Once that's created, then you have an opportunity to move assets into that private trust and do that as you wish. So is there tax implications? It depends what you do and how you're doing it. But the bottom line is when you participate in their system, it is always voluntary. It's by your signature, by your consent. So if you're moving a piece of property from, let's say, a taxable entity like a corporation, and you're wanting to move that into a trust, you can do that very easily by a quitclaim deed and move that property. The difference is the natural law trust is not a taxable entity because you're not seeking the government's permission to exist. You're coming to them saying, I'm incompetent, therefore I'm asking your permission. And I realize I don't want to be harsh about this or talk down to people. I just want you to understand that's how the government sees it. When we go to them to ask permission, they consider us coming as incompetent. Okay. So they'll always say yes because they can charge you a fee for saying yes. And then they can charge you a fee every year. And that's the rent that you pay for them to be your partner. Okay. And you get to join in with them and they get to tell you you're taxable. So these are the things that are occurring. There is a lot of, I know questions about it, and I'm not a tax attorney, and I'm not going to get into the tax law. What I'm saying is, as a trustee, as a responsible individual, you need to know what contracts you're entering into and which ones you're not. And as long as you do that properly, you're going to secure for yourself and your family your property that you can pass down for generations, and no one else is going to be able to have a say in that. So there's a lot of changes that are coming in our world. We've talked about some of this in the past. There's going to be a lot of changes with taxation. There's not time to go over that tonight, and I don't think we should, because I think this is about trust. But the whole idea is if you use these trusts properly, and I know very, very wealthy people that have used these for a very long time. Some of them are a couple hundred years old, and they've passed down the wealth. And is it a taxable entity? No, because it is a private trust. It was never a part of the tax system. So when you go to a lawyer and you seek their help to form a trust, they're going to give you one option, and that is to create a statutory trust, meaning let's go to the state and get their permission to set this up. Why do they do that? Because they're told to do that. They're told their license could be taken away if they don't do that. So lawyers are going to steer you in a direction that they think protects their license rather than what may be best for you. And I'm not anti-lawyers. I have lawyers in the family. Okay. It's just that you need to understand the transaction and where you're placing yourself. And I think that's a part of us waking up as a people, as a world, and becoming self-responsible. It goes all the way back to, God telling Adam, have dominion and take responsibility for the earth. And that's essentially what we do when we create these natural law trusts. I hope that's helpful.
Very helpful. Thank you so much, Will. While you were talking, I did text Randall and said, "Did you lose internet?" And he texted back saying yes, and he expects to be back on soon. So sorry, everyone. He's having internet trouble today. But thank you, Will. Those are excellent comments. I might just want to add or clarify which kind of tax we're talking about, that the trust is an exception to income tax filing and paying. Now, when it comes to property tax, that's a whole other issue. The trust all by itself is not going to exempt a property from paying property tax. There are other methods for dealing with that, which could include just not registering it on the county recorder, you know, and going for the allodial title, things like that. Would you agree?
Yeah, I agree completely. I will, if you'll oblige me, I'll share a little story that I had with a title company a number of years ago. Had a piece of property I was looking to acquire, and I talked to them. I said, "Could you handle this transaction for me? I'd like you to accept my funds, to handle the escrow, and to disperse it to the seller, excuse me, so I could purchase the property." "Oh, yeah, we could do all this for you." And I says, "Well, I want you to do a property search, and could you search that all the way back to the initial land grants?" They said, "What?" I said, "Yeah, the original land grants. Can you give me a title search that goes all the way back to," in this case, it would have been, I was in Tennessee at the time, but Tennessee was a part of North Carolina as one of the 13 colonies. Okay. So this goes back to the original grants from the King of England, rather, as one of the 13 colonies.
You just blew her
And,
mind.
and they were like, "Well, we'd have to send somebody to North Carolina to figure all that. That would cost a fortune." I said, "Yeah, it would cost more money. Could you do it?" I don't know. I don't know if we'll do all the stuff in Tennessee. We'll go back as far as we can. I said, "Okay, one other request I have." I said, "After we conclude the closing, I'd like you to hand me all the warranty deeds and I will handle the recording myself." "Oh, no, we can't do that." No, no, we're required to do the recording." I says, "Excuse me, can you show me the law that says you're required to do the recording?" And so this woman gets off the phone. She comes back a few minutes later. "We can't do that. We're not going to do your transaction." Well, upon further investigation, what we discovered was the county tells this is actually state and county, but they tell the title companies, if you don't register the deed, and I'm going to use that term correctly, register the deed, we will pull your title license and you're not going to be able to do closings anymore. So they push them they were trying to maintain their license. So by maintaining their license, they're going to push you back into a taxation situation that you may not desire. If you own a deed to a property and you do not register it, register means give it to the government. Okay. That's the simple form of it. Give it to the government, and therefore you will pay rent on it the rest of your life as a tenant, which is why you pay property tax. If you don't register it, they cannot tax you because, again, they can only tax what they own. And it's the same with tags on your car and everything else. If you register your car, you'll get a title back that'll say the state of, pick the state, California, whatever, right at the top of it. That means the state owns your car, and they'll have a block there that says owner, and it'll have your name. But you can change that owner thing to just say tenant, okay? Because that's really what occurs there. So the only way to remove property taxes is to no longer to consent to register property into the system. And that's a whole nother thing, which you're right. Tonsa, this would take all night to discuss that. Whole nother topic. But I just wanted to kind of bring a little bit of clarity that, because it's important that we understand what relationships we're entering into when we're signing agreements and contracts. We need to be very careful about that. Hope that helps.
Absolutely. Thank you so much. And it's a little bit of an aside to the trust topic, but it's also very helpful and relevant and related. Then just go ahead and please stay on. But Deb has her hand raised. So, Deb, let's ask you to unmute and go ahead and say hi to us.
Hello, Tansen. Very good to see you. My question came up during Will's last comments, which were really good to hear. I'm wondering about when I registered my trust from you. I originally had it registered as a foreign trust, and I had to register. Well, I did follow instructions, Randall's instructions on getting an EIN number. At that point, I'm wondering if the distinction between asking for permission from the government to be taxed or not, because what you're doing is you are requesting a tax number so that you can get a bank account, but you are registering it as a private trust. So I'm wondering what would cause that to be distinct from registering in the IRS's mind as needing to file.
It doesn't create the government being in any kind of position of authority over the trust. All it's doing is applying for an ID number for banking. That's it. And they don't know much about it because you don't give them much information. They don't demand much information. They just want to know the name of it, who's the responsible party, that responsible party's social security number. And the responsible party could be anybody, right? It doesn't have to be you. And the type of trust, the word we always use, as you know, is irrevocable. Irrevocable. So that's it. You know, they don't know who's behind it. They don't know but what maybe you've got the Rothschilds or the Rockefellers behind you. You know, that's all private information. So that's why they tread lightly on it. They don't interfere. They don't retaliate. They don't investigate. They just leave it quiet, leave it well enough alone. And the private contract remains private. It remains sovereign because it's not drawn up under the geographic jurisdiction of any particular government or state. You see? So
Perfect.
yeah, don't worry about the ID number. I've even given my own SS number as the responsible party. And again, there's no compromise. Why? Because I realize and I've documented that I am separate from that all caps name. As long as you've documented yourself properly and identified yourself in the government databases properly, you separate yourself from that fiction all caps entity that to which the number is assigned. And that number, therefore, is assigned to the Sesquiqui Trust, the fiction, not to me. So I have the right as a sovereign to interact in commerce and interface with the system using that vehicle. That number is the vehicle in commerce. So I have control of it. I use it. I sign on there as the responsible party. No trouble, no inquiries, no challenges. There have been no problems for anyone, any of our trust clients. We've never had a problem with the taxing agency or with any kind of challenge to our authority or our sovereignty or our ability to control the trust to our discretion.
Wonderful. Okay, well, that leads then to actually what I meant by the child trust was at second trust as an under the umbrella of the parent trust. So in other words, if I wanted to separate out holding one trust for the property for a major property and another trust for a business, to have separate beneficiaries, but to have them all linked together under the parent trust.
So it's a question of terminology, nomenclature. Okay, well, we understand. Child and parent, or we just call them subtrusts. So Randall is very good at consulting on that. You would just ask him. He's an expert in estate engineering. That's where you layer trusts. So many of the wealthy families who have trusts, they do that. They layer them, put one under another. make one the beneficiary of the other, and so forth. And so he can counsel you on how to do that.
Wonderful. Thank you so much.
Thank you. We're still waiting for Randall to come back.
Yeah, there's a couple of good questions. One from Robert, another one from Eddie. He said he couldn't figure out how to put his hand up, but he put a message in there. This is me putting my hand up. So I guess he wants his hand up.
Okay, so you want to handle it?
Sure. Can you unmute Eddie so he can ask his question?
Well, let's see. It's in alphabetical order by last name. Eddie, do you know how to raise your hand? I don't want to give out last names on the show.
Look in the meeting chat. You'll see it.
Okay. So I see Eddie's text, but Eddie, if you click on the icon to raise your hand, or yeah. Okay, there you are. Asked to unmute. Okay,
Unmute.
there you are.
Okay.
Hey,
Sorry, my bad. Okay, going back to the question I had earlier. You somewhat got into that, so I just wanted to back up a little. So my corporation is actually a silent corporation, and I'm using it basically as a division for my private ministry. So I have the number corporation, but I'm acting as a private ministry. So I had a senior who wanted to donate property to the ministry for a legacy. So I received one document is a purchase and sale, no funds, that was attached to a quitclaim deed. And the quitclaim deed is addressed to the number corporation. So what I'd like to do is I'm trying not to keep it registered because it's been in her family for maybe 40, 50 years. And now I don't want to take it from there and put it back into the public registry under my corporation or my name. So from the corporation, I'm trying to avoid registering it with the registry. Can I just take the quitclaim deed that the corporation received and put that into the trust and create a legacy?
Yes. Will, would you like to elaborate?
Like, I believe I can, I just don't know how, and that's the answers I'm looking for.
all you have to do is have a quit claim assigned to the name of the trust. And then you do a trust minutes to accept the quit claim.
The quitclaim deed that holds the property is assigned to the corporation. So what's the next step? Because I was told I had to take the quitclaim deed and register it with the government, but then that means I abandon it, and I don't want to do that.
Then the corporation is the one whose signatory, CEO, would
Yes.
sign to the transfer of the title of ownership, the quitclaim, to the trust.
Okay, so with me being CEO of the corporation, I then deposit the quitclaim deed directly into the trust.
Correct.
Okay, thank you.
Are there any other officers of the corporation who would be required to sign on that besides you?
No other officials, no other, yeah, it's just me.
Okay. Well, that's the simple answer, and then the exact procedure Randall can assist you with.
Right, okay, perfect.
Yeah.
Now with the legacy as well, I could also put the grantor who originally gifted the property as a beneficiary until, because I want it for the legacy so that the trust doesn't expire. Because I believe, with my understanding, if it's the ministry legacy and I use the property, it can go on without expiring. Is that correct?
You don't
Not
want to have a
exactly.
trust that is into perpetuity. That would invalidate the trust. But at 21 years, you can renew it. and you can renew it in perpetuity every 21 years.
Right, I see. Okay. Okay.
The renewal is simple. You just hold a meeting of the Board of Trustees and you sign a meeting note saying we've agreed to extend the trust another 21 years.
Yeah.
That's
Right,
it.
okay.
So,
Right,
so
okay.
it's not a public document. It's really just a private document, but it's important to have it.
Yes.
Right, okay. Okay. And one last clarification there. So the corporation would fund the trust with the quitclaim deed, and then I, as the CEO for the corporation, would then become the trustee?
If you wish.
Okay.
And do you intend to continue keeping the corporation?
I'm not exactly, once it's deposited into the trust, I'm really don't want to be too active with the corporation, so I might dissolve it.
You could dissolve it, yeah, and just work with the
Yeah,
trust.
I don't want to do any business in the public that way. I'd rather work from the private capacity of the trust.
Well, I think you are a very wise man.
Oh, thank you. With all that confusion, it's okay, thank you.
Very well.
Anything a corporation, an LLC, or any other entity can do, the trust can do.
Right, that was my understanding.
There's no difference in functionality.
Right,
Right.
only better and private.
Yeah.
Right, okay. Okay.
I'm going to read this question from Robert Tonson, but I'm going to let you answer it. In your natural law trust, what are you specifying as the
Thank you.
situous domicile and governing law?
That's a very, very important question. It's covered on the website. It's covered in the ebook, but briefly, the reason we call it non-statutory is that it does not subscribe to the jurisdiction of any particular geographic location anywhere on the planet. That's very important to understand, even though we we recognize that it's difficult for newcomers to wrap their minds around. What do you mean by non-statutory? Most people never heard of that word, you know. It basically means it's operating under the universal right of private contract, which is intrinsic. It's intrinsic, meaning it's a right all humans are born with. It is affirmed in many, 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 many Supreme Court cases throughout America and around the world, and by bodies of law such as the Uniform Commercial Code and others. Okay. So it's affirmed, it's supported, it's confirmed, but that doesn't mean that the trust is written under their statutory authority. It's just that those bodies of law agree with us in that. That's why we call it natural law. You and I have the right to go into contract with each other privately without the government interfering with it. The government has no right to interfere, as is stated in Supreme Court cases, unless we're harming someone by this contract, if we're violating someone's rights or harming them, taking their property without permission or consent, that sort of thing. But as long as you're not harming anyone or violating anyone's rights, no government anywhere has the right to interfere with private contracts. So that's why we call it contract law. And there are different aspects in statutes, of course, that govern contracts. But the fact of contract law itself is universal and intrinsic and is not derived from any permission body of law. So that's why we call it natural law. That's the law on which it's based. And therefore, the question of domicile doesn't arise. There is no domicile, except that on the page, I think it's page 3 of the trust, where it says the location for disputes, basically the location for where the common law would apply in case there's a dispute. You have to give that, right? So in that case, you would pick whatever jurisdiction you want, where you live, where you'd like to live, where you'd like the trust to be based. So the common law of such and such a state, such and such a location, in case there ever is a dispute that needs to be litigated, you would want that. You would want some kind of geographic jurisdiction to have it brought into court for limited jurisdiction, limited only to the transaction itself, not to the trust. You understand? So it's not subjecting the trust to that jurisdiction for permission to exist. It's only subjecting it in a limited way for the transaction litigation, and that's it. All right. And so that's what's written into these trusts, and it's up to you as the client, as the creator, to where you would like that to be and how you would like it to be stated. All right. So
pick your country.
pick a country, pick a state, anywhere you wish, and make that and again, emphasize common law, even though some believe common law doesn't exist, but if you know how, it can be invoked. Yeah.
Awesome. Rich has a question. I'm only allowed to apply for EIN number online for the first EIN number. They're asking me to mail or fax my EIN application. Is this method safe? I would say that it is, because I did mine via fax and had no problem. So,
What country are you in? Because United States, it's all done online in 15 minutes. Yeah, okay. Pamela,
I had a request to send mine in via fax, but they responded to me like, right away. It was pretty quick.
very good. I know in
Oh.
Canada, I think it's still by postal mail or fax or something.
Yeah.
Okay, Pamela, let's ask you to unmute and go ahead and give us your question if you like.
Hello, everyone.
Hi.
So, hi, I found you a month ago when I bumped into your website, Tansen, with Will doing his monthly update, which was fabulous. Loved it. You're just great, Will. You're the way you talk, the way you come across, just honest. You know what you're talking about, and the two of you together was just great. So anyway, I fell in love with the whole concept and what you're doing. So I went to your website and I'm learning all this stuff. But in the meantime, the last 3 years, I've bumped into other groups that are doing all kinds of stuff, the sovereignty thing. And my biggest thing has been to search for, I know my property taxes are not right. And we just pay more and more every year, and we're going to get kicked out of our house because we can't afford the taxes. They're so high. We live in a high-end neighborhood when we didn't spend a lot of money to buy the house to begin with. Anyway, so that's been my goal. And one group that I found a few months back, I'm not crazy about because of how they are, but the method they had was that they would convey, and I put the question in the chat, but it's maybe easier to explain it. That's why and maybe it's out of this. Maybe it's not part of what you do, but I just wanted to put it out there to see if it's something you've heard of. Or what they do is they put the property in a trust, a common law trust, and then they created a conveyance document, and then they convey the property from me, I guess, to the trust, and the trust is anonymous. You take a notice to the county clerk and you say, this is a conveyance notice. This property no longer belongs to me. It belongs to this trust. They want to know who owns the trust. And of course you say they want to keep it private, so they never know. So now that's the essence from what I remember, because I haven't done it with them. I'm not working with them, but I took a few Zoom calls from them, and this is what I remember. So then once the property is in this trust, the county doesn't know who owns it. When they start sending the person that still lives in the house, the former owner, me, bills, I can say, I don't own this property. And eventually, I guess they go away because they don't know who really owns the property. Is that something that you heard or you do, or is that kind of kooky and not something we should do? Or I don't know. So you guys seem like you really know your stuff, and I have a feeling of trust for you. So just wanted to put that question out there if it's something that you're familiar with.
That's a fantastic and wonderful kookiness. I love it. I think you're brilliant.
Yeah, thank you.
You're absolutely, because you're being honest. You're telling the truth.
Yeah.
Yeah. That's Will, what do you think?
The only way to remove something from the tax rolls is through a transfer of ownership. But if that new owner is not registering that transfer, they can't bill the new owner. So technically it would work, I believe, but you need to look at each of your states and counties, how they deal with that. But it sounds like it's reasonable because
Right.
again, if the new owner in this case could be a trust, well, it could be any entity, it doesn't matter. Once they receive the property, it's up to them to register that deed. Now, 100 years ago, we didn't have deed registry offices. We only had recorders' offices. It was after the Federal Reserve came into play that they began converting these recorders into registry offices. Okay, so there's a whole history about how this happened over the last 100 years. Prior to that, there wasn't any property tax. It never existed. So this is most all of these taxation systems are all a creation, if you will, of the bankers. They wanted a way to fleece the people, and it worked wonderfully. The counties and states liked it because this was a new source of revenue they didn't have before, and so more money for them. So they want to keep it going. But the reality is if that deed is not, let's say you transfer a warranty deed into a trust, let's use that as an example. If the trustee of that trust doesn't register that deed with the county, they can't send the trust a bill. And if you as the former owner say, I don't own this property, I'm sorry, I can't help you, they can't bill you either. So it then becomes what's known as deregistered in the system.
So in essence, it looks like that is a workable solution around the property tax.
I've heard of it happening before. I was familiar with a guy in New Hampshire that had 40 acres and he wanted to give 5 to his son to build a house on. His son had just recently married. He wanted to help him get a start on life. So he goes to the county and he says, look, I'm sectioning off this 5 acres. Here's the dimensions of it. I need you to reduce my property taxes by 5 acres because I don't want to pay for what I'm giving my son. The son never went and registered the 5 acre deed. He never got a tax bill ever. Okay.
Yeah.
So,
Okay.
again, if we once we learn and understand the jurisdictions that we're in and the interactions that we're embracing, we can choose: do we want this relationship or don't we want this relationship? And if you stay in, like I said, the definition, a true owner is someone that can decide if something is taxed or not taxed. And you do that by the actions you take with your property and how you record it and whatnot. So
this group calls that living in the private or living in the public. If you choose to live in the private, you don't register anything, including your marriage certificate. You're getting married, you do it on your Bible, your car, all of that.
They're not wrong. They're actually not wrong. When you apply for a marriage certificate, where did these come from? Where did the marriage licenses come from? You have to do a little research on this. I'll tell you, marriage licenses began after the Civil War when you had some mixed race couples that wanted to marry, and none of the ministers would do this. Oh my goodness, I will not marry somebody that's a mixed race situation. So they would go to the court, the courthouse, and say, we want to get married. Will you allow us to do that? Well, yeah, if you pay this fee for a marriage license, we'll let you do it. But really what it is that this, again, it's a self-admission of incompetence to ask their permission. Okay. So when you do that, the state's then saying you're incompetent, therefore we're now a party in the transaction. So when you get a marriage license, there's 3 parties in the marriage: you, your spouse, and the state. Now, what happens if the state decides you're not raising those kids properly? Well, they can take them because they're a part of the marriage.
It was the same in feudal England when you had the lords of the manor and the peasants, right? And they were like slaves, they're kind of owned by the lord of the manor. And when they wanted to get married, they had to get a license from the lord of the manor.
Can I ask one more question on the property and the trust? I like to get that, in fact, I'm gonna sign up for the trust that you're doing there, Tansen, and so yours is called a natural common law trust. Will that, I guess, supposedly work for me to put my property in there? I mean, it's, you know, the same kind of trust that they were probably talking about.
It's better.
That it's, yeah, sounds like it from what I've heard
I'm
you
biased,
talk
but it's
about.
better. I've
believe
looked
it,
at
I believe
other
it.
ones. I've looked at other ones, and Randall
believe it.
is an absolute master.
And can I put the business and the house, or you recommend that we do one or the other? So do two trusts or do two, could I put my 2, 3 assets in the one trust? Is it
Ideally, a trust for
recommended?
each one, a separate
Okay.
trust for each one. And
Okay,
you can be trustee on each trust.
okay. All right, can't wait. I'm excited about it. Thank you.
Thank you so much for these intelligent questions and fantastic success story.
Thank you. And Will, I can't wait for your next update. I'm sure it's probably every couple months, but I keep waiting for time to go so you can give us another one.
If things go well, it may be out by this weekend. So yeah.
That'd be
Well, I'm thinking
wonderful.
maybe October, next month, we'll have Will back.
Yeah, we'll definitely be with Brilliance in Commerce in October. Absolutely.
Yeah.
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 I think we've got Gail trying to put her hand up as well.
Gail, go ahead and speak to us if you like.
Hi, thank you so much. Thank you to everyone. I wanted to ask, along with Pamela's question and Will's example of being at the closing and having the title company say that they wouldn't do what he wanted them to do. So in your answer to Pamela, it's kind of like I go ahead and open a trust for the property that I want to buy, do things the way the title company wants them done, then open another trust and sweep that property into that other trust. Is that correct? Oh, Tansen, we can't hear you. You're muted.
Good question. That it's sad that we live in a world where you need to do it twice. Okay. Now, in some states, closings can also be handled by attorneys, and you may have attorneys that are willing to do that and just hand you the deed and you walk out with it. Okay. So you'll have to look at your state. I don't know what state you're in, but each state is a little different how they handle that. So even though you may have difficulty getting a escrow title and escrow company do it because they're worried about losing their license. The same thing happens if you go to, it's like if you go to a car dealer and you ask them, hey, if I buy this car, will you give me the manufacturer certificate of origin? And their face will turn white when you ask them that. Because they're worried they lose their license again, you know, as a dealer if they hand it to you. But when they submit your registration to the state, they send the manufacturer certificate of origin to the state. Do you know what the state does with it? They shred it. It goes in a shredder, and then they send you back, you know, state of California, Arizona, whatever state you're in, on the top of the title. So that's cars. But as you look at real property, there's no reason you couldn't choose, because there's no law that tells you have to record it. Find the law. It doesn't exist. There's no federal or state law that says you absolutely have to record a property transaction, a real property transaction. So I don't see why you couldn't find somebody in your state, whether it be an attorney or someone else, to handle the transaction, that they couldn't just hand you the deed at the end and it's up to you to record it.
Okay. In absence of, I'm in California, in absence of finding an attorney that would do that, would the other plan work to just go through the closing as usual and then open another trust and sweep the property into that trust?
I think theoretically, I think it would,
Okay.
but you know, I don't know California law, so I'm not helpful there.
It's okay. Thank you so much for the answer. I just had one more quick thing. we were talking earlier, and I believe Townsend said that the responsible party would have to give their social security number. I would be the trustee. I'd be the responsible party. Do I have to have removed myself from the tax system because I have not done that yet before opening? Okay.
No, not to operate the trust. It's still a good thing for you to do, but that's a separate issue.
Okay, very
It
good. I
doesn't,
will do.
you mean when you're trying to get an EIN to open a bank account?
I already have
Is
the
that what you mean?
EIN, already have the trust, but when I go to the bank to
Oh,
open the bank account, I didn't know if I had to have removed myself from the
No,
tax system. I
no.
will be doing that, but I haven't done it yet.
The best
Okay.
way to do it is on the BIC website. You go to
Yeah.
resources and you scroll down to freedom from tax and go to number 4, which is the revocation of election. So when you're ready, for all Americans, that's recommended to do to remove yourself from the tax system authorized by Congress, 100% success rate, never failed. It's a one-time action, a one-time filing. You're done. You are officially exempt. And yes, we use the word exempt for the individual in your personal name from there on for the rest of your life. But it's not required to operate the trust.
That's perfect. Thank you. I'll be doing that and I'll be using the information for debt um, problems. Also, I'd always filed jointly with my husband, Greg. I don't have to say anything. He can just file singly now, correct?
He can file singly if he wants to.
Yeah. Okay. Thank you so much. I appreciate all the information.
when,
Thank you.
I'll just say this, when you file and you sign your name at the bottom of a return, it is a self-admission you're a taxpayer.
That's right.
You're putting your signature there that you are a taxpayer. And so they can, if they don't like your numbers, they can say, oh, you're wrong on your numbers and you were trying to, fraud us or whatever. Is it better to them to just complain you didn't file or to come at you and say your numbers are wrong? I don't know. It's up to you.
Yeah. It's like joining the army, It was voluntary in the beginning, but after you've joined and you're enlisted, now they tell you what to do, and you can't even leave voluntarily. So it's kind of like that. And that's why the revocation of election is revoking your election to have done that in the first place because you have new information. Let me address Shirley before we go on. I see, Deb, you have your hand up again, but we've got a lot of other people. Shirley asks, can you use 2 unrelated witnesses rather than a notary on trust documents? Yes and no. In common law, that is respected. It traditionally, for centuries, you have 2 witnesses to your signature, it's considered good. The only thing is that when you go to a bank or some financial institution, they might want to see that that document was notarized by a state official because it places it on state record. And I'll give you another example. For those who are holding foreign currencies that you expect to see revalue, if you want them to be out of any possibility of capital gains tax after the RV, you would want to have their transfer to the trust notarized by a state official because it puts it on public record the date when the transfer took place. So if the RV happens after that date, then the capital gains accrue to a non-taxable entity, the trust, and they can't tax it. Will, do you want to add anything about notaries or witness
Good
signatures?
point. I always, when it comes to the documents into the trust, I always get it notarized. For this very reasons that you stated.
Yeah.
People don't question a notary. So I've done the same thing. I've transferred assets in and out of the trust. I always get those documents notarized, even though it's technically a trust minutes document. I still get it notarized so that there's no question about the veracity of that.
Right. Because if it's just 2 people who are witnessing it, in a small community where the state is not involved, it might be okay. But if it's ever challenged in court or by any statutory body, they're going to want to see that document was witnessed by a state official placed on the public record. Well, we have a number of more questions. Okay, Deb, let's just make it quick. I'll go ahead and ask you to finish whatever you wanted to say to us.
Thank you so much. I was just wanting to get back on Pam's question on the taxes for properties, because I'm concerned that once the property is on the state or county register, the taxes would keep accruing. So if they don't know who to send the bill to, they still would have that tax burden assigned to the property. And so that's why I'm wondering how you would get out of that.
Will, what do you think?
I'd have to understand the situation of your specific state. I was responding to another question that was a direct question that came to me on the chat, so I only caught about half of what you said, and I apologize
She's saying that
in
the
advance for that.
property tax would go on accruing even if they didn't know who to assign it to. It would just go on adding and adding and adding.
They may do that, but it's it doesn't matter. What are they going to do? They can't. They say if you are registered and you're not paying your taxes, what do? They put up what's known as a tax sale. So you're going to have this situation where they're going to sell your property out from under you. Okay. If you're not paying your property taxes. But if it's not registered, even if they're accruing some amount, what are they going to do? If it's not registered, how they can't force you, they can't sell your property. There's nothing they can do. And eventually they're going to just stop accruing because there's nothing more they can do to do that. So you'll probably reach, they may accrue it for a number of years, but eventually they're going to be like, what's the point of this? And they'll just pull it off the record.
Right. It's like sending a bill to an addressee that cannot be found. Yeah.
Perhaps you could put a lien on the property for the value of the property in your own name, so that if they did sell it to someone else, that person would have to pay off the lien first to you.
Yes.
Okay, thank you.
Yeah.
These are excellent considerations. Thank you. They're somewhat related to the trust topic, but so let's see, what else do we have here? We addressed the question, Robert, in your natural law trust, what are you specifying as the situs, domicile, and governing law? We answered that question earlier. If you missed it, we will post this on our YouTube channel and you can review it there. What's next?
Rich had an interesting question that I think is probably best you answer, but I will read the question. Can the trust participate in private placement programs even if the trustee in the trust doesn't meet the accredited investor threshold?
As an entity, it has the full right to participate, even if it's not publicly disclosing its assets. But of course, you will be asked for proof of funds to get into a private placement program, and those funds should ideally be in the trust bank account, and they would have to be of sufficient size to be admitted into the program. But other than that, the trust doesn't have to be publicly registered and shouldn't be. But yeah, that's ideal. It's better than a corporation or an LLC or your personal name as a holder of the assets and a receiver of the profits that would be generated. I hope that answers your question.
That's great. Robert had a very interesting question. I don't know if I know the answer, but I'm going to read it. In your natural law trust, do you have an automatic migration provision So if the trust comes under duress from U.S. courts or creditors, and there's currently a U.S. person as a trustee, that the trust will automatically migrate one or more substantial decisions to no longer be controlled by a U.S. person.
No, no, it's not controlled by a U.S. person because we are not, you know, the definition of person in the Internal Revenue Code is a fictional entity. So they've corrupted the common word person. And also US, of course, usually refers to the corporation. So, the trust is controlled ideally if you recognize it in your own understanding and your own consciousness. You are a state citizen, you are a sovereign. And if you're trustee, that is the status of your individual name that controls the trust, and there's no migration necessary.
I don't see a need for this for a movement to another trustee. As a trustee, you're not the owner. Why would they be coming at you as a trustee? There's no reason for that. So I think when you begin to use these types of entities like a real natural law trust, you find that a lot of these issues that maybe you had with other entities in the past are just simply not there because you're now behaving in a way that is different because you're in the private now versus the public space. And so you can expect some different responses.
Thank you. Well, and that brings up the point that the trustee is not personally liable for the affairs of the trust. The debts, the obligations, any judgments cannot accrue to the individual trustee. Right.
Awesome. Did we get to everybody?
No,
We were still waiting for Randall, but I don't think he showed up.
Randall never got back. Yeah, I kept checking, and it's just something about his internet or something. He just
He
disappeared.
got a big wave and it knocked out his internet.
Gail says, if I am the responsible party trustee at the bank when opening a bank account for the trust, do I have to have removed myself from the tax system? And we addressed that. The answer is no. Do not accept. Okay, Robert, you have it on. Okay, you addressed the migration question. Rich, can the trust participate in private placements? Yes, we discussed that. Were you suggesting two trusts, one personal and one for the business, or were you suggesting more than two trusts? That depends on your life situation. It depends on how many assets you are, what you have in the way of net worth, whether you have an organization, if you have more than one business. The basic idea is never put all your eggs in one basket. That's kind of the traditional cardinal rule of asset protection. So the more assets you have and the more activity you may have in terms of social organizations, memberships, maybe a spiritual center. It could be an environmental organization, a scientific institute, an educational center. It could be a business selling products or services. Depending on how many of these you have, you may want to trust for each different one. And you may want at least one for your domestic situation. Again, depending on your asset level, your number of activities, and how many people are involved, right, in your affairs. So the more people, the more assets, the more trusts you may want, is a simple answer.
In other words, take different possibilities of liability and sequester them into their own baskets so that they're not affecting any other assets that you may have. In other words, sequester a liability into its own basket. Therefore, it's not going to affect any assets, and perhaps you might lose some assets because that liabilities have given you an issue.
Thanks, Will. Yeah, that elaborates and clarifies. Very, very good. We're getting close to the end, but Dawn, you have your hand up. Let's see what you have to say. Share with us. If you can unmute. Go
Okay,
ahead.
can you?
Yes, yes, yes. You have a nice icon of hearts in your image.
Oh, yeah, those pink stones, those are pretty. I wanted to ask how much you charge to write up a trust contract, and is that a charge for each trust contract or just, or like if I need a second or third one, does that include that or not?
Well, thank you for the question. This is not intended to be a sales presentation, but to answer your question, we have a sliding scale. If you're a millionaire or someone with high assets, the price is 10,000. We have a separate website for that. So you should show your dignity and pay what it's really worth if you have that asset level. But we, many years ago, also created the sliding scale to $2,500, 75% discount off the 10,000, because there's a much larger number of people out there who cannot really afford 10,000, but they still need some kind of asset protection, either to protect whatever they already have in a smaller scale, or because they're anticipating a windfall soon, or maybe they're worried about a divorce. They want to protect what they have, and they can't really pay the higher price. And we try to give the same VIP treatment to all price levels. And then for those who don't even have 2,500, we have a $250 a month, 10-month installment plan. So we're trying to accommodate all economic levels.
Oh, that's very nice.
There
Thank
is a
you for,
discount if you buy more than one in the same purchase. So if you get two, the second one is 10% off. If you get three, the third one is 20% off. And then fourth, fifth, sixth, and seventh, same, 20%.
oh, okay. Thank you for answering that.
Thank you. Well, everyone, thank you, thank you, thank you. It's been fantastic. A lot of great questions, comments. Will, thank you so much for assisting. You've been awesome. And we want to hear your news, a full presentation in October. And there'll be a lot more to comment on by then, I'm sure. So
I'll just give you a sneak peek. October is going to be absolutely lit with activity. And in fact, as we get into next week, some things are going to start heating up. If you thought it was crazy, buckle up. It's going to be really interesting. We're entering Red October, so we'll probably do this around the middle of the month. There's going to be a lot to report on. In fact, I won't be able to touch on it all, but I'll try to keep it kind of concise and to the point so you get the idea. Because we're undergoing a massive change in the whole world. All legacy systems are being brought down and we're rewriting our future. And it doesn't come perfectly smooth. There's going to be some bumps along the way, but as long as we know that we're headed in the right direction, I think it's easier for people to endure what comes. So it'll be fun.
did you see that cartoon in my newsletter? And it shows the board meeting, and they're looking at the financial bar graph on the screen, and it's showing the up and down of the economics. And the last one looks like a stick of dynamite. It's been lit. And, and the comment was, looks like the fourth quarter is going to be rather volatile.
Yes. I loved that cartoon. I thought it was perfect. I don't know who created it, but you couldn't have been more spot on. It's for those that I'm not an astrologer, but I kind of follow it just as a point of interest sometimes. As we get into October, starting on about the 2nd of October, we are actually in an astrological alignment that is perfect for change, for massive change, and to go in new directions. And so is that a coincidence? I don't think so. There's a lot happening.
Awesome. Well, it wasn't planned that Randall would disappear. I was as surprised as you are. And I don't know what happened to his internet, but thank you so much, Will, for helping me. And you're a great addition to our team. And thank you, everyone who listened and asked questions and made comments. You're wonderful.
Thanks, everybody. Have a good night. We'll see you next time.
Absolutely.